Thank you for joining us. We want to walk you through the most important changes under the CARES Act, which is aligned 42 CFR Part 2 with HIPAA, and what these changes mean for your organization. Enforcement began on February 16, 2026, and the HHS Office for Civil Rights is now fully open for business on Part 2 complaints and breach notifications, with penalties now mirroring HIPAA enforcement. So the stakes are real.
Part 2 has always been about protecting patients seeking treatment for substance use disorder from stigma, discrimination, or legal consequences. Part 2 was really a shield written to make sure that someone could walk into a rehab clinic or talk to a counselor without fear that that information would follow them back to their employer or into a courtroom. But historically, those protections created operational friction, siloed records, repeated consents, and blind spots in care. The 2024 final rule modernizes that system without weakening confidentiality. Now that Part 2 has been aligned with HIPAA, it supports better coordination of care.
Now let's review some of the biggest changes you need to know. Number 1, single patient consent. Now this is the game changer. Patients can now sign one consent that allows future treatment, payment, and operations, or TPO, disclosures across the HIPAA ecosystem. No more chasing signatures for every disclosure, no more frozen records that can't move with the patient. This rule change supports integrated care while preserving patient control over non-TPO disclosures.
Number 2, breach notification. Part 2 is now fully aligned with HIPAA, meaning that if substance use disorder information is breached, Part 2 holders and their business associates must follow the same requirements you already know for HIPAA, and that is notify affected individuals, report to OCR, and notify media for incidents affecting 500 or more individuals.
And number 3, a unified notice of privacy practices. Now, Part 2 programs must now issue a notice of privacy practice that clearly explains how substance use disorder information is used and protected. HHS has now provided a model notice to make this process any easier. Now let's discuss what has not changed under this rule. Core privacy protections remain intact. SUD records cannot be used in criminal, civil, or administrative proceedings without explicit consent or a court order. Disclosures beyond TPO for employers, law enforcement, or family still require patient authorization. And public health and research disclosures remain tightly controlled.
Enforcement has begun, so this is no longer theoretical. Every organization that touches SUD information, even once, must update consent forms and notices of privacy practices, align HIPAA and Part 2 policies, train staff on redisclosure rules and patient rights, update business associate agreements to include Part 2 obligations, identify and label Part 2 data across their ecosystem, and map workflows end-to-end, intake, care coordination, billing, HIM, and legal.
Policy gives us the blueprint, but workflows are where compliance either succeeds or fails. This alignment closes a 40-year gap between how SUD data and all the other health information are managed. It enables safer, more coordinated care while preserving the dignity and privacy of patients. And ultimately, that's the point. Better care, stronger privacy, unified standards. If you would like to learn more about the Part 2 alignment with HIPAA, please watch our full video, available to you free of charge.
As organizations work to meet these new requirements and strengthen their overall HIPAA compliance, North Country Communications can be a true partner. We help teams move from awareness to action by providing tailored training, workflow redesign, and compliance solutions designed specifically to help small and mid-sized healthcare organizations.
Our approach is practical, plain language, and grounded in how care is actually delivered. Whether you need a readiness assessment, updated policies, or scenario-based training for your workforce, North Country Communications can help you build a privacy program that is defensible, aligned, and ready for OCR scrutiny.
Compliance isn't just about meeting a deadline. It's about building trust, As experienced former regulators, we're here to help you do just that with clarity, confidence, and tailored workflows. Contact us today at 877 North 20 or info@northcountrycommunications.com for a free confidential consultation.